There were 2,000 calls and 9,700 text messages, which is an average of 6.2 calls and 29.3 texts per day. Oh my gosh. There are people who do this? How do you even get anything done? Bradley proved significant information and assistance for 5 months, and then edited and even confirmed the motion. He was editing Ashley's filings. Witness Willis, another prosecutor, watched Fani instruct Bradley, don't speak to anyone about my relationship with Wade. Fani is witness tampering. Fani Willis blasted Trump's defense and Steve Sadow filing their appeal in Georgia. Remember, Fani is trying to hang on to this case for dear life. Nathan Wade, her lover, out in the pasture now, enjoying the media, getting lambasted by The Daily Show. And so now Trump is working to get Fani off the case as well, so she can go join him and they can cruise to their little heart's content. Sadow, Trump's defense attorney, posted this as an announcement before the appeal was dropped. He says, here's my statement. As lead counsel for President Trump in Big Fani's case. Says, all right, good morning, America. President Trump has filed his opening brief in the Georgia Court of Appeals. Says the brief persuasively argues that the trial court should have dismissed this case and disqualified Big Fani for her forensic misconduct and the appearance of impropriety between her and former special assistant Nathan's hot dog, who was her lover and taxpayer-funded financial benefactor and co-conspirator. We are optimistic that the court will favorably decide the appeal in our favor. And so let's jump right into it. This is what it looks like, submitted by Trump's defense in the Court of Appeals, state of Georgia. We know the case is Donald Trump versus the state of Georgia. This is on appeal, which is why these got flipped around. An interlocutory appeal, which is in the middle of a criminal case, because this is really consequential. If Fani is disqualified, the whole case might go away, and you can't have the case continue on while that question lingers in the air. So this is the opening brief for the appellant, Donald Trump, and it's just opening because what Sadow is reserving is an opportunity to come back and amend this thing if need be. Trump's defense team appealing Big Fani Willis, the biggest Fani in Georgia, Grey Goose and Cruises, says, all right, Judge of the Court of Appeals, the panel, this all-important interlocutory appeal in the middle of the criminal case, Your Honors, presents a novel issue concerning the legal standard for, quote, forensic misconduct that Fani Willis committed. Now below, Judge McAfee found that Fani Willis, he said that she gave a, quote, legally improper speech. McAfee said that. And that there was a significant appearance of impropriety that existed. He even admitted it. But he didn't order the remedies that are required if you find that to be true. And so what happened is McAfee really failed on this thing. He didn't apply the misconduct standard. If he found that these things happened, in fact, the remedy needs to match. So here's the question. Court of Appeals of Georgia. Should a prosecutor be disqualified for intentionally and repeatedly violating ethical and professional canons so as to prejudice the defendants for their personal and political gain, going on cruises, drinking Grey Goose, storing cash, funneling 700 grand to your hot dog lover? Should that be a problem? Yes! And is disqualification necessary when a prosecutor testifies falsely and conceals their misconduct and creates a stinky odor of mendacity that results in a significant appearance of impropriety? Should they go? Yes, undoubtedly so. And if this prosecutor deflects attention from her own misconduct by claiming on national TV that Trump and other defendants in this case are dishonest racists for bringing the truthful accusations to light, could anyone anywhere have any confidence in the impartiality of this prosecutor? No, absolutely not. Great question, Steve, and great answers. Now, since launching this investigation, Fani Willis has engaged in a pattern of consistently flouting her ethical obligations. She's already been publicly chastised. She's already been twice disqualified by 2 other judges, but McAfee didn't have the stones to do it. Now, because neither fully removed her, Willis has only become emboldened. To this day, Willis continues to ignore those clear warnings. She didn't care at all. She's out there. She's like having even more Grey Goose. She's going on more cruises, making it crystal clear that her improper conduct was neither inadvertent nor isolated. This is her lifestyle, man. She's Big Fani Willis. Don't you even dare question her. Willis has put her personal, financial, political, and romantic interests not only before her own professional integrity, if there was any at all, but more importantly, the due process rights of the defendants. Willis has taken full advantage of her position to poison the well. Willis believes she's immune from disqualification no matter how badly she acts. And in her view, she explicitly states that a particular defendant is guilty. She said that clearly. Now, this is not and cannot be the law here in Georgia Court of Appeals. This is madness. The trial court's order expressly found, McAfee, that Willis's actions, including hiring Nathan Wade as her lover and accepting gifts and trips that she paid for through financial taxpayer compensation, says created a financial cloud of impropriety that cast a pall over the proceedings. The order from McAfee determined that Willis's out-of-court speech when she went on the churches and said, "Why, God?" And we said, well, it's because you had sex with him. That's why. Now, the order determined that her speech was legally improper, that her conduct at the disqualification hearing was unprofessional, and that her sworn testimony was both dubious and likely false. She lied to McAfee's face, and so did Nathan Wade, and he sat there and took it. The trial court was required to unequivocally disqualify Willis. Now, this remedy, this stupid thing where he was saying that only Wade needed to go, didn't address this at all. It didn't cure this. It didn't mitigate this. It didn't alleviate the odor of mendacity. It still stinks. Now, the Supreme Court has long recognized that our public's faith in the integrity of the criminal justice system is critical to its functioning. And this is a great cite here from Berger versus United States, 1935. And I believe this is absolutely true, which is why it's such travesty that our justice system is evaporating before our very eyes. Courts have an obligation to ensure that legal proceedings even appear fair to all who observe them. Not anymore. Our system of law has always endured to prevent even the probability of unfairness. Not anymore. Now, nowhere are these interests more important or on display than in a high-profile case involving Trump. It's captured the attention of our nation. We need our public confidence in our prosecutors. But make no mistake, Willis, Big Fani, by persistently untethering herself from the legal, ethical, and professional constraints of her very powerful position, she has decimated the integrity of these proceedings. Sadly, the circumstances that require her disqualification are entirely self-inflicted wounds that were within the power and her power to avoid. She disqualified herself. Absent the removal of Willis in her office, the odor will continue to loom and stink. To give effect to the rules, this court must conclusively disqualify her and must dismiss this indictment. So, Court of Appeals, you have an obligation here. The facts are bad, but the consequence to the profession of the law are worse. Here's some background. Writing, on January 8th, co-defendant Michael Roman, via Ashley Merchant, moved to disqualify Fani based on personal financial stake that she acquired through a secret relationship with her lead prosecutor. The Roman motion alleged that Willis hired Wade, paid him $650,000. He made a bunch of money from that. Now, evidence revealed that from October 2022 to April 2023, and we covered all this live, Wade incurred over $17,000 in credit card charges. They took a bunch of vacations. Miami, Aruba, the Bahamas, Napa Valley. And there was, I think, over 6 months. It was like one trip a month. Willis admitted that she was also the recipient of day trips. They also went to Tennessee, Alabama, South Carolina, North Carolina, Georgia, lunches and dinners. Man, it was nice. These expenses were neither shared proportionally. They weren't even tracked because Big Fani paid in cash, baby. Willis could only produce a single receipt for plane tickets totaling $1,300 in an effort to offset the $17,000 that she got paid by Wade. We split things, 50-50. Now, Wade testified that expenses were paid on his business cards because for safety reasons, she would limit her transactions. I spent, so her name wasn't out there because she's the biggest Fani in all of Georgia. Everyone knows who she is. Says, we can't even walk through an airport or sit at a restaurant because of all the attention, which is strange because they walked through a bunch of airports and sat in a ton of restaurants and went on multiple cruises. Now, no evidence suggested that her bank accounts or credit cards were ever monitored, however. Now, long before this is Trump's appeal, the Roman motion was ever filed, before this was all busted, she had already engaged in a pattern of conduct designed to prejudice the defendants for her personal gain. Beginning 2 days after launching the investigation and continuing unabated to this day, Willis has made widely publicized extrajudicial statements to the media about this case. She's got heightened ethical obligations to not do this. And prosecutors do. They have all of the charging power of the government, and they have the high public position of being the chief prosecutor. So they've got the power of the media, the power of the office, and the power of the charge. And then she also runs her mouth. Now, Willis was previously judicially disqualified by another judge. 2 years ago, Judge McBurney said that Willis had created an actual and untenable conflict of interest by publicly naming the Lieutenant Governor Jones a target of her investigation, and then she went to a fundraiser and headlined the fundraiser for his opponent thereafter. So she goes and campaigns for the opponent and prosecutes the other guy. It's sick. Judge McBurney then took the unprecedented and unlawful step of carving out the target of the investigation rather than the conflicted counsel. Okay, so even that judge was like, well, she is the biggest Fani in Georgia. Even I can't deal with her. 4 days after Roman moved to disqualify Fani then, the trial court told the parties we were going to to have an evidentiary hearing. Now, in spite of, or perhaps because of, the pending hearing, Willis now tried to prejudice the defense and to distract away from this and to conceal the scope of her conduct. And so 2 days later, after the whole thing blew open, while facing intense media scrutiny, Willis went to the MLK Jr. holiday weekend and dumped all over his name, gave a keynote speech at the Big Bethel Church, which is a historical black church in Atlanta, knowing this speech would be covered by everybody. With a notebook of prepared remarks, she went into the podium and she committed her premeditated pattern of prejudicial public statements about the defense and their counsel. Now, this time, however, in her zeal, she upped the ante in 4 ways. First, she maligned the defense and their counsel. She called them dishonest. She said that God told her to pray for their souls, deflecting from her relationship with her special counsel. Second, she brought race into this. A black man, she said. Why are they targeting me and a black man? I have a white woman and a white man. Well, were you sleeping with the white woman? I don't think so. Were you sleeping with the white man? I don't think so. Which is racist, by the way. Third, Willis strongly intimated that the defendants were guilty and would be convicted, saying, my superstar team has a 95% conviction rate. All we do is win, 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 no matter what. And fourth, Willis appealed to religion by saying that God was on our side. Why, God? She says, why does Fulton County Commissioner Bridget Thorne and so many others question my decision in special counsel? Lord, your flawed, hard-headed, and imperfect child, I'm a little confused, is what she said. I appointed 3 special counsel, as is my right to do, paid them all the same hourly rate. They only attack one. What is going on? It says, I hired 1 white woman, a good personal friend, and a great lawyer, a superstar, I tell you. I hired 1 white man, brilliant, my friend, a great lawyer. And I hired 1 black man, another superstar, a great friend, a great lawyer. Oh Lord, they're going to be mad when I call them out on this nonsense, right? I'm not going to read the whole thing in Fani voice, but oh my gosh, it was insane. A 1 black man who you were sleeping with, Fani. So she goes through, they copy and paste the whole thing. 2 weeks later, a New York Times bestseller was released about Willis and the ongoing case, saying she's a hard-charging prosecutor. Knowing this book would be published before trial, according to the authors, Willis sat down for multiple interviews, gave them significant time and access. Now, in those interviews, she also thrusted into the public the forefront allegations of racism against her and her office by telling the authors that comments against her were always racist, right? Race, race, race. Now, having publicly castigated the defendants, calling them racist and saying that I'm fighting on behalf of God, Willis began her efforts to conceal from the court the nature of her misconduct. Willis opposed Roman's motion with an affidavit, and Nathan Wade falsely averred that their romantic relationship did not begin until 2022. Lied to the court. On January 17th, Willis also filed for a protective order in Wade's divorce proceeding, saying that accusing Wade's spouse, Jocelyn, an innocent party to this, of conspiring to harass Willis. So she basically threatened Nathan Wade's ex. Willis asked the court for time to investigate this. Now, coming from an elected DA, this could only be viewed as a threat of criminal prosecution to Mrs. Wade in violation of the rules, which prohibits that from happening. So Fani is also threatening exes of Wade. Now, overwhelming evidence proved this case was false, right? Their relationship did not begin in 2022. Robin Yurdy, close friend and former employee, testified that Willis's romantic relationship with Wade started in 2019. How'd that happen? Well, we witnessed that. We saw them acting as a couple, and there was no doubt it began before Nathan was hired. Yurdy was also corroborated by text messages sent to Ashley Merchant by Terrence Bradley, a longtime friend and a partner of Nathan Wade, which he confirmed that the romantic relationship absolutely started in 2019 when Willis was a judge in South Fulton. They met at the judicial conference, and they really liked how their robes looked on each other. That evidence was also further corroborated by defense analysis of Wade's cell phone records. Those records established that before Willis hired Wade, his phone was in the general location of Willis's apartment on 35 occasions, including at least 2 overnight visits, before she hired him. So what were they working on? What kind of legal cases were they staffing together at her residence overnight, working on their motions? Yeah. Now, 11 months of cell phone records prove that during the period that Willis and Wade claimed not to be romantically involved, no, we're just friends, there were 2,000 calls and 9,700 text messages, which is an average of 6.2 calls and 29.3 texts per day. Oh my gosh. There are people who do this? How do you even get anything done? You don't. What are you doing? Like, you have to be on the phone all day to talk to somebody that much. So unable to provide receipts, credit cards, or bank statements statements demonstrated that Willis actually repaid 17 grand. Willis and Wade testified to a wholly unsupported explanation. They couldn't produce any records, no withdrawals. She said I paid him back in cash. No deposits, no discussion of repayments. Willis testified she kept large amounts of cash in her home. She says, I built it up over the years because when I go to Publix, I get cash back, you know. Would you like cash back with that? She says, yeah. I need to add some more to my mattress. It's feeling a little bit loose on the left side. By taking cash from her campaign account, which might also violate campaign finance laws, but we don't know about that. No one cares. So both were barred attorneys. They both have law licenses. They apparently passed a bar exam somehow and also ethical tests. And Willis is an elected constitutional officer from Georgia. It's amazing. Had reporting requirements that, and she's probably going to win again. They love it. Like the only thing that Fulton County wants is more Fani Willis, baby, to track and disclose any expenditure on her behalf that exceeded $100 in a year. Nevertheless, in 2022, Willis falsely certified that she had no gifts or benefits over $100. That is falsification of a business record. It's right there. She as a public official, falsified a business record. Trump got hit with 34 felonies and didn't even falsify anything. Paid his lawyer for legal services. She says, signed a document under oath, certified falsely. And here's the testimony. You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were repaid by Miss Willis, do you? No, sir. And when you got cash to pay him back on these trips, did you go to the ATM? No, lady, I didn't. Willis also received thousands of dollars from Wade, who was literally a prohibited source under Georgia law because she hired him. Can't do that. So we know how this went down. On April 14th, grand jury came back, indicted Trump. He denies the charges. On January 8th, Roman moved to dismiss the case, saying Willis needs to go. The trial court notified parties. We had a hearing. Willis went on MLK Day holiday, screamed at everybody, called them all on the opposite end of God, racist, Satanists, I guess. And following the church speech, Trump then adopted Roman's motion. Now, augmenting the grounds for disqualification, Trump also took the position that the speech that she gave was forensic misconduct. Not only should she be disqualified for her affair and her conflict of interest there, but she dug it deeper. The trial court heard hearings on the motions. Many people testified. We covered it all here. On March 15th, though, the trial court, McAfee, entered an order granting in part and denying in part. The order held that Trump and the defendants failed to prove an actual conflict of interest, but had proven an appearance of impropriety. Now, Fani says that none of this really matters. She says, well, what the judge found that the facts are what the facts are. We're asking about the legal standard. To remedy this appearance, the court proposed a forced election. Fani needs to make a decision. Willis goes or Wade goes. And so Wade abandoned ship, took his 700 grand, dropped his kids off in Europe and X'd his ex-wife. I'm out here. Peace, fam. So the trial court criticized Willis's behavior. They called it unprofessional. Yeah. They called it a tremendous lapse in judgment. Yeah. They said there's an odor of mendacity. That's true. It's stinky. The trial court labeled the cash repayments as unusual, stated the lack of supporting documentation was, quote, understandably concerning, and held that there existed a, quote, financial cloud of impropriety. Nicely done. But then the judge whined out like a weenie and stopping just short of calling their cash repayment testimony an outright fabrication, which it was. The trial court half-heartedly said that it was, quote, not so incredible as to be inherently unbelievable. So the order found a need to dissipate the potential untruthfulness of the proceedings. It noted, so it's like you just split them up. Okay, you two, you're broken up now. But Mom, I really love her. Sorry, Robbie, you're not going over there again. She's bad for you. So the judge, you two get over there. So it noted that the reasonable questions, this is what the judge is doing, questions about whether the DA and her hand-selected DA hot dog guy testified untruthfully about the timing of their relationship. And we have to cure this. You do that by getting rid of Fani. Now, despite acknowledging that the courts have an independent interest in ensuring that these are conducted according to ethical standards, the trial court punted, which was pathetic, Willis's numerous legal and ethical violations to other forums like the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, and the voters of Fulton County. Such a cop and so spineless, man. Judge, she lied to you in your face, in your courtroom. Offer feedback? How about you offer some feedback on the fact that you got lied to on your face, man? On forensic misconduct, the order expressly found that Willis's speech was legally improper and it was not inadvertent, so it was intentional. It then issued Willis a stark warning. It said the time may well arrive for a gag to prohibit you from talking. Now, despite its findings, which all but acknowledged forensic misconduct, the trial court still weenied out, refused to disqualify based on a restricted application of the interpretation. They said, well, judge said, I don't know what Williams means, this case, Williams versus State. And so because I don't know what it means, unmoored from precedent, I don't know what to do. And so I feel bound to hold hold in confinement of Williams. And so we move for appeal, and the brief now follows. So here are the enumerations of error. There are lots of problems here. The trial court abused its discretion. Both of them should have gone. You can't just keep one. The trial court also erred by not dismissing this, because we've already articulated why. They say when reviewing a lower court standard, we have to follow certain rules, which we'll do now. And here, let's explain why the court interpreted this case wrong. So in Fani Willis's attempt to get the Court of Appeals to reverse their acceptance of this appeal, she talked a lot about the facts. But now, as you can see, we're going to be talking about the law. The trial court erroneously excluded Willis's knowing and intentional prosecutorial misconduct. Should not have kept that out. And they truncated its factual analysis as well. So some facts coming in. Now, the broad standard that necessarily reached Willis's knowing and intentional deliberate, it's a broad standard coming out of this case. So forensic misconduct means, after all of that analysis, what is it? Any activity by the prosecutor which tends to divert the jury from making its determination of guilt or innocence by weighing legally admitted evidence in the manner prescribed by the law. Any activity. See how broad that is? And it's not any activity which tends to divert. Very low standard. So it's broad. So if Willis knowingly did it and intentionally did it and deliberately did it, well, that seems like it hits that standard. So that you'd call that then any activity. She had notes. She came out in front of a church. She referenced the case. She was talking about the motion. Courts have an independent interest in making sure they're following the ethical standards. Courts. You don't just get to say, well, Fanny's not my kid, so I'll let her parents deal with it. It's your house, judge. The trial court noted that Georgia courts have not hesitated to step in to disqualify, but omitted Willis. Thus, any activity clearly matters here. Without a doubt, Willis's nationally televised intentional injection of racism is clearly going to heighten the public and their prospective jury and their concerns and their condemnation of the accused. They haven't come up with any exceptions to this. None of this speech was necessary to her job. She directed her comments at the motion, and she concealed from the public her improper relationship. She didn't tell us about it. She had bad faith there. The state below made no argument that there was any legitimate reason for this speech, because there wasn't. There's no doubt that this speech was an activity. The standard says it's broad, very broad, any activity. She also talked about 95% conviction rates. She was casting racial aspersions. She was calling the defendants dishonest. She said that God was on her side. She was begging the congregation to pray for their souls. My team is amazing, and we're doing God's work here. She inverted the burden of proof, said that they have to prove their innocence, not we have to prove their guilt. And now finally, Judge McAfee pathetically put the cart before the horse, saying the order acknowledged that there was prejudice, but then didn't do anything about it. She needs disqualification. There's no slap on the wrist here. There's no don't do it again warnings. There's a finding of forensic misconduct, and she needs to go. And so when there are improper statements, the law says it's appropriate to move them off. Willis's personal motive was material and palpable here. There's a pattern of egregious comments here. At the other end of the spectrum, okay, Willis prepared a speech, and her speech came out. It was intentional. It shows a lack of judgment, lack of impartiality, a lack of fairness, which is what this rule's about. And her additional misconduct also shows she has a calculated plan here. There are similar attacks by her. She gave isolated summary analysis, and there's multiple things. One, there's a speech. She made prior statements saying that these people are guilty. She published "Find Me the Votes," and there was a submission of a false affidavit and false testimony. Each one of these things is an activity that justifies her removal. No reason she should be injecting racism here. She's done this repeatedly. In her church speech, she said it. Black man, white woman, one white man. They're all the same, but not really, because she's only sleeping with the black guy, which is very racist of her to do that. She recited the conviction rate. She's appealing to religious authority, calling out her superstar team 95% conviction rate. Now, the context of this matters. She knew that there was going to be heightened public attention on this. She did not take these premeditated steps because she was free from temptation or bias. No, this was her personal and political need. She was obscuring the misconduct by slandering the defendants. And this is similar. It's even worse than these other cases. Willis, in the other case, by contrast, in this case, did not react to an onslaught of press at the courthouse steps. No, okay? She wasn't getting asked questions like being bombarded. She wrote a speech. Only after the court scheduled the hearing did she come out and make her speech. But she wasn't responding to media questions either. She pre-scheduled the appearance. She did it on MLK Day. She made it as public as possible, and it shows this was a calculated plan. This was not something that was off the cuff. The trial court didn't even look into this, how it was a plan. Just 2 days after announcing the launch of her investigation, she sat down with Rachel Maddow. By the time this came down to an indictment 6 months before the indictment, Willis had given 40 interviews. Willis has frequently spoken publicly. She talks about fake electors, talks about a bunch of stuff that's not legitimate for law enforcement officials to talk about, but she's trying to prejudice the defense. Even after being twice reprimanded by McAfee and McBurney, and being disqualified on another case, and being warned, she still is now out there speaking. On March 25th, she said, "I'm not embarrassed by anything I've done," she says. "I guess my greatest crime is that I had a relationship with a man, but that's not something I find embarrassing in any way. I'm allowed to do that." She's happy as can be, man. She just beat the MAGA team. So speaking with CNN, she called herself the face of the feminist movement, remember? She said the train is coming for Trump. Willis said the following Friday, poking at the court's order, she said, "It's hard out there always having to prove yourself 2 or 3 times. Recently they tell me they don't like me to talk about race. Well, I'm going to talk about it anyways. I don't care." Willis, sitting directly in front and agreeing with Rev Motley, talked about the Florida man with resources of hell and the Florida man who is saturated with evil, right? Talking about Trump, obviously. So lots of statements from her that she just continues to speak out about. Maybe if Judge McAfee would have done something about this, she would have not been able to say those things, but he didn't do that. Unlike the singular comments in these other cases, Willis has an extensive pattern. It's all premeditated, and she's continuing to do it even after they warned her about a gag. Now, there's also this Find Me the Votes book. It's a best-selling book called Find Me the Votes. The trial court's order failed to consider whether the contents of the book also show her plan. The order mentioned Find Me the Votes in only 1 sentence. But by viewing that book in isolation, you also ignored the invocation of God. You also ignored the racial aspersions. All of these are extrajudicial comments. Willis is thrust into the public forefront. She sure was, by saying everybody's always racist. The timing of this publication, viewed together with their efforts to conceal this, show there is a conspiracy here. And also, in a desperate bid to stave off disqualification, Willis undertook to conceal her misconduct. First, Willis knowingly filed a false, fraudulent, lying affidavit, a false business record that should be a crime, with her response to the disqualification motions. And second, Willis and Wade gave false testimony and lied to the court. On February 2nd, Fani's office opposed the disqualification motion. They attached an affidavit from Nathan Wade, where he averred that he met Willis in 2019, but it was only in 2022 that they developed a friendship and a professional association. We know that's not true. Overwhelming evidence showed that Wade's affidavit was known to be false when it was filed by both him and Willis. For example, Robin Yurdy testified the relationship began 2019, no doubt about it. Beyond Willis telling Yurdy about it, Yurdy observed it. Yurdy gained these details through a long-standing close relationship with Willis. Indeed, the two were so close that in April 2021, Willis took over the lease for Yurdy's condo, the condo where she met with Wade, their little bang house. Now, Roman's counsel only learned about the hate-built condo and Yurdy through Terrence Bradley. Yurdy's testimony was also corroborated by Bradley's text, facts which McAfee failed to consider. He didn't want to say that they lied to his face. He just didn't want to admit it, which is just cowardly as can be. Like, you have to deal with stuff, come on. When it determined his testimony left too brittle a foundation upon which to draw conclusions. Too brittle. Dude, come on. There were texts. Bradley was on the stand squirming in his seat. Bradley proved significant information and assistance for 5 months, and then edited and even confirmed the motion. He was editing Ashley's filings. Anything else that isn't accurate? He says, no, looks good. After being called to testify, Bradley suddenly forgot everything. He claimed his knowledge was gained exclusively through confidential communications with Wade. When Bradley was forced to testify, suddenly he feigned ignorance. I don't know. And he was impeached with his own texts. Bradley's text confirmed that the relationship had absolutely, his words, started when Willis was a judge in South Fulton and he was married. Willis and Wade confirmed that Willis moved into the Hateville condo and conceded Wade occasionally visited, even though the relationship was not yet romantic. They were working at each other, yeah. When asked, Wade dubiously claimed, many reasons why I might be over there, but stated he was there, no, not more than 10 times. No, maybe 10 times. When pressed, Wade could only muster 2 unconvincing reasons. He said, I don't know. Maybe I was over there visiting Yurdy, or maybe I was over there to review a document I received. I don't know. Wade failed to explain why he would do either when they were just merely friends. I don't know. Why do you need to do that? We got this from Yurdy and Bradley's texts sharing this that were corroborated by the analysis of Wade's cell phone records, which showed an average of 6.2 calls and 29.3 texts a day during the period where they said we're not dating, April 2021 to November. Just working on stuff. These records disproved their testimony and that Wade would not have been at her apartment more than 10 times and that he never stayed overnight. He said never did. Yeah, you did. Wade's phone was in the general location of her condo on at least 35 occasions, including at least 2 overnight visits. Now, unable to argue that this data was incorrect, the state state analysis claimed, they said, this did nothing more than demonstrate that Wade's phone was located somewhere near the densely populated, multiple-mile radius where a lot of other stuff is located. There's residences over there. There's bars. There's nightclubs. Now, Wade's admission that he would visit the condo during this period corroborated Urity's testimony. Okay, so now Urity gets a +1, that she witnessed romantic interaction. The trial court failed to consider this. Even Nathan is confirming Urity, which means Urity is highly credible. It corroborates what she said. You can't say that Urity was lacking context. No, Nathan agreed. He confirmed, corroborated it. So, leaving out the fact that most businesses are closed overnight, the state failed to explain why Wade would have called the elected DA for 40 minutes while on the way to the area, and then why Wade texted Willis at 4:20 a.m. once he got home. Made it home, baby. See you at the office later. It's the got home safe text. We all know if he was in the area for some reason unrelated to visiting Willis. Like, what's all that for? There was nothing to explain. Wade was visiting Willis. Now, the evidence was further corroborated by the testimony of Cobb County ADA Yeager, who was likewise told by Bradley about the beginning date of the relationship. And that was the offer of proof that was submitted. Yeager, another Cobb County DA, remember we read this, witnessed Willis, another prosecutor, watched Fani instruct Bradley, don't speak to anyone about my relationship with Wade. Fani is witness tampering. Now, the trial court refused to consider Yeager's testimony. Another prosecutor, but the mounting evidence of evasive tactics and impeached testimony supported a calculated plan that required disqualification. And that was so insane. Okay, another prosecutor in Georgia says, I watched Fani try to basically threaten a witness and tamper with a witness who's going to be the subject of a court inquiry. Incredible. Judge says, don't want to hear about it. DA Willis, her false testimony and her evasive tactics. We continue. Trump's defense, Steve Sadow appealing Fani's disqualification. Prosecutors have a heightened duty of candor. You owe the court, the tribunal, a high duty of care. And she dropped well below that. She testified untruthfully that she started dating Wade April 2022. That was false. Willis and Wade intentionally concealed the true nature of their relationship, and they made a false statement to the court. Robin Urity confirms that. Bradley's text message confirms that. Bradley himself confirms that. Wade testimony that he did not reveal his relationship with Willis, and a bunch of other testimony supports that as well. But the ethical violations did not stop there when they lied to you. Willis's inveracity was further illuminated by three distinct actions. One, efforts that she undertook to prevent and tamper with key witnesses like Bradley and Wade. She requested a protective order in the divorce proceeding, also threatened Wade's ex-wife. She also falsely certified with false business records that she had no gifts or benefits from prohibited sources. Nathan Wade was one of them. Now, the trial court was faced with understandably concerning circumstances, giving all of this, cash repayments, lack of documents, and so on. But as a result, it found, quote, reasonable questions about whether Fani and Wade testified truthfully. And the judge said that there was an odor of mendacity that lingered. Now, despite these damning findings and the significant ethical violations uncovered during the hearing, the order declined to disqualify Willis and her team. The trial court avoided only the appropriate remedy, by truncating the disqualification analysis, by limiting itself to Williams. They glossed over everything, and this was reversible error. He did it intentionally because he wanted to get reelected. He didn't want to be the bad guy. He's going to make the Court of Appeals do it. Now, once the trial court found that there was a significant appearance of impropriety, there's only one thing you can do: disqualify each affected prosecutor and the entire office. Here, both Willis and Wade were both affected prosecutors. They both committed specific conduct. The trial court's forced election to get rid of Wade was insane. This appearance was caused by both of their conduct. Willis decided to continue supervising and paying Wade. She made bad decisions. Willis's regular and loose exchange of money with Wade without any verifiable measure of reconciliation. Actions taken by both parties in favor of Wade's divorce. Willis's legally and improper speech made in his defense, and Willis lying. All of that was her misconduct. Why does she get to stay around if she's clearly committing ethical misconduct? Now, this concept makes sense. A lot of case law here, but the trial court did a bunch of analysis and they drawed a bunch of flawed analogies. There was no screening here, nor could there be. Okay, Willis and Wade ran the prosecution team. This entire investigation was under their control. It's not like those other cases. In some, the trial court's forced election remedy misapplied the relevant law, and therefore it abused its discretion. It found in its own order that there were two people who were problems here. Both Wade and Willis were affected by their significant appearance of impropriety. And if that's the finding, they both have to go. Withdrawal of Wade failed to cure the appearance of impropriety that the court and Fani created through her own misconduct. And so since they made a mistake, unlawful government misconduct occurred, and now this case has been encumbered. Willis's speech was legally improper. It was not inadvertent. Wade led the grand jury, and so Trump incorporates all of this into his request. Prejudice is happening here. The court and other state courts have already found fundamental unfairness where a conflicted private prosecutor is present for and participates in the grand jury proceedings. So Wade was conflicted. He led the grand jury proceedings, so the entire case is tainted. Wade's conflict existed from the inception of this case. Wade was therefore not an authorized grand jury participant, violates due process. This should have been dismissed. Wade's frequent presence and participation and control of the grand jury proceedings is undisputed. So if Wade's gone now, and he brought the grand jury proceeding also be gone? Since being hired, Wade played an integral role both before the special purpose as well as the regular grand jury. He was literally the lead prosecutor. Wade not only called witnesses, he presented testimony, but he was also responsible for educating and instructing and assisting the grand jury as it considered the indictment. Throughout his tenure, Wade operated under the conflict of interest that has now disqualified him. And because the appearance of impropriety found by the trial court existed, the grand jury process was not fair. Indictments that are obtained by conflicted prosecutors have to go. And this is particularly true here because of the staggering misconduct of both Willis and Wade. And so reversal is therefore required. In conclusion, wrapping this up, they tell us DA Willis and Wade engaged in deliberate, calculated plans and patterns of misconduct. They had heightened ethical duties and they failed. Knowing full well about the unethical nature of her church speech, Willis is a career prosecutor, the biggest in Georgia, chose to rectify the reputational harm that she caused herself by creating a flagrant lie. This blatant lie that the defense was racist caused the utmost damage before a group of people, all potential jurors who she knew would be most affected. And after choosing to take the stand to explain her misconduct, Willis testified falsely in violation of her heightened duty of candor, and undeniable intentionality rings through her persistent disregard. The totality of her actions establishes why she must be removed, lest she continue to act with total disdain, as she's doing now, for the administration of justice and her prosecutorial obligations. As Judge McBurney noted when he disqualified Willis, the public can't be burdened by this. And so we need to deal with this now. That was true 2 years ago. It's true now. The circumstances of this case demand Willis's disqualification. To decide otherwise would be taken by Willis as an imprimatur of her playing the race card wherever she so chooses. And so for the foregoing reasons, President Trump respectfully requests that this court vacate the order denying the disqualification of Fani, send this case back down to Fulton County, Scott McAfee, and make him disqualify Fani Willis and conduct further proceedings as necessary. Signed by Steve Sadow with help from Jennifer Little and Matthew Winchester, attorneys for Donald Trump, sent in on appeal. And so we're excited to see where this one goes. Trump's defense, Steve Sadow, going up to the Georgia Court of Appeals, trying to disqualify Fani Willis. She's still on the case for whatever reason because, well, Scott McAfee's kind of a weenie and didn't do the right thing that a judge with any respectability would do when they get lied to in the face. But we got Fani Willis, who is now going to be responding to this. We've got a motion from her that's already out there pending with the court, which she's asking the Court of Appeals to reverse themselves, to deny the interlocutory appeal. In other words, don't hear this case. So Trump filed his appellate memo. Fani will respond. I'm sure Trump will respond to the removal attempt by Fani Willis. And so we'll see what the Court of Appeals does in Georgia. Hopefully they continue to hear these arguments because they're the right ones. We'll continue to cover this, my friends. We hope the Court of Appeals does the right thing. We think that they will, but time will tell. Thank you for joining us as our coverage here continues. We're covering all the Trump litigation, the 2024 shenanigans, and more. We appreciate you hitting that subscribe button. Thank you for liking our video, and thanks for inviting someone you know or love to come over and join us when we go live, or just share this video with them so they can see what Trump is fighting in these courts in Georgia. We got a great segment coming up next. We're going to be talking about a gag order victory that Donald Trump has secured in New York just days before the debate. So stick around, click over to that video. We'll see you there and back here on the next one.